Technology Committee will come to order, and the clerk will please open the roll.
You have a quorum, Mr. Chairman.
Thank you. We've got a lot of bills to get through today. What we're going to do is we're going to take up bills similar to those that we've heard before first. I know there was a lot of interest in the Petersburg casino bill from Delegate Taylor. Is Delegate Taylor here? Okay, Delegate Taylor. The bill that you introduced is similar to Senator Morrissey's bill?
Yes.
Is that right?
Correct.
Rather than take testimony from both sides again, because the committee's familiar with the issue, I wanted to give you a chance if there's anything you want to say in summary, and then take up any discussion from committee members for you.
Of course.
If that's okay. Okay. Did you want to begin?
Yes, thank you. Good afternoon, Mr. Chairman and members of the committee. Petersburg has suffered from significant economic decline over the past 40 years. The city once flourished with manufacturing employers such as Brown and Williamson, who offered good-paying jobs for residents. I cannot overstate this when I say that allowing Petersburg to have a referendum and approve a casino and resort will transform the city. I want to bring attention to the fact that the current average yearly salary in Petersburg is $26,000, while the yearly salary of a Cordish job would be an average of $60,000. This would absolutely be transformational for our city. Thank you for your consideration, and I hope you will vote to help Petersburg flourish once more.
Thank you, Delegate. We had considered Senator Morrissey's bill. We had an amendment, the last time it was in this committee, and I understand there was an amendment that was being offered. Senator Barker, did you have an amendment? Yes. Okay, or substitute. Ashley, could you explain to members of the committee the substitute from Senator Barker, how it may have differed from what we had before?
Yes, Mr. Chairman. So this substitute is slightly different from the one that was offered for Senate Bill 780 when it was heard in this committee. And that's going to be posted online shortly. Give me 1 second. In that we add contractors and subcontractors at every tier to language dealing with the proposer's commitment to paying its employees. So now it's paying its employees, contractors, and subcontractors at every tier have to be paid no less than the prevailing wage rate. Also, there are additional enactment clauses that were added to the bill on the very last page that direct the Virginia Lottery Board to amend their regulations to include prevailing wage as part of the licensure renewal process anytime a casino gaming operator seeks licensure renewal after the 10-year period. Yes.
Okay, so there was a substitute that was moved. Is there a second?
Mr. Chairman, could I ask a question first?
Senator Bell, you had a question, yes.
Question, and I think from what I understand the way this is explained, this would apply to all of the existing casinos. Is that correct, or would it only apply the next time they get licensure?
Ashley, do you want to answer that for us?
Mr. Chairman, Senator Bell, this language would apply to any casino that does not currently have an operator license. So if this bill were to pass and go into effect July 1, then that language dealing with prevailing wage rate would apply to any casino that has not yet, or any eligible host city who has not yet chosen a casino gaming operator. And then it would also apply to any eligible host city and casino gaming operator during the renewal period, so after the 10-year period. Does that answer your question?
So Mr. Chairman, if I could follow up?
Yes, Senator Bell.
Okay, so I'm trying to make sure I understand you right. You're saying it, yes or no, it does apply to the existing 4 projects?
Mr. Chairman, Senator Bell, yes.
Yes, it does?
Yeah, in the sense of renewal and further stages of their licensure process.
Okay, so
yes.
would it only apply when they were renewed?
Yes. We're not going to go retroactive to those who have already sought and procured a license from the Virginia Lottery Board. But as far as their renewal process, then this language would apply to them.
All right, Mr. Chairman, Speaker
Bell.
Mr. Chairman, I'd like to hear from the patron. I mean, because frankly, I think
Sure.
it's kind of unfair that we're doing this to one project, that what we didn't, something different we did the others.
Sure.
And I'd like to hear from the patron, please.
Delegate Taylor, did you want to comment?
Well, I thank you, Mr. Chairman. I accept the will of the committee and would appreciate your advancing this legislation.
Thank you. Okay. So we have a substitute that's been moved and seconded and explained. Those in favor of adopting the substitute will indicate by saying aye. Aye. Those opposed? No. Okay. Could the noes raise their hands? Okay. So that's okay. And then the ayes. So. Okay. So that fails.
Mr. Chair, move to report the bill.
Okay. It's been moved to second, moved and seconded to report the bill. Now, this has no prevailing wage amendment at all on it, so it's a little different than Senator Morrissey's. So those in favor of reporting the bill will indicate, oh, and refer to finance. Yeah, so it's a report and refer. Please indicate your preference on the voting board.
Ayes 9, noes 4.
Okay, so congratulations, your bill is advanced to finance.
Thank
Okay.
you.
Now, my intention was to take up the bills that were identical and similar first, so that we can move through them a little bit rapidly. From Delegate Batten, we had HB 1911 dealing with foreign gifts. I understand we don't need a substitute to be identical to where we were, do we? I've got on my, it says version reported from House General Laws with amendment, with amendment nature of a substitute, with the definition change. So is what's before us identical to what the House version, to the Senate version that we passed, or is there a change? So we don't have to adopt anything new, okay. Okay, is there a motion on HB 1911 from Delegate Batten on the gifts from foreign countries of concern? Our bill number was SB 1002. That was from Senator Cosgrove. The question is there a motion to report Senator? Okay, so there's a motion and a second to report HB 1911. Indicate your preference on the voting board.
Ayes 8, noes 7.
Okay, so that bill reports. Now we've got the pony bill from Delegate Bloxham, HB 1951, is identical to Senator Lewis's bill. Is there a motion and a second? Okay. The designating the Chincoteague pony as the official pony of the Commonwealth. Indicate your preference on the voting board, please.
I just gave you my proxy.
Thank you. Okay.
Ayes 15, no 0.
Now, from Delegate Tata, we have the Virginia Real Estate Timeshare Act alternative purchases identical to SB 969 from Senator Mason, which we passed unanimously. There's a motion and a second to report HB 1955. Please indicate your preference on the voting board. Okay. Now, From Delegate Krizak, we have HB 1987, identical to SB 1209 from Senator Reeves, dealing with charitable gaming. Okay, there's a motion and a second to report that. Please indicate your preference on the voting board. Okay. Now we've got.
What's his proxy?
Sorry about that. Okay, thank you. Okay, HB 2113 from Delegate Bulova is identical to Senator McPike's SB 1036. Oh, I'm sorry. Does this need to go to finance, or does it?
Oh, the previous vote needs to be.
Mr. Chairman?
We'll get to you. Yes. Did we not describe the previous motion from Delegate Krizak's bill? Did that need to go to finance?
It does.
Okay, so do we need
Mr.
to
Chair,
revote that?
move to report and re-refer House Bill 1987 to Finance.
Okay, please indicate your preference on the voting board again. Okay. Now we're back to Delegate Bulova. Delegate Bulova?
Yeah, Mr. Chairman, so my bill deals with a similar subject matter to Senator McPike's Senate Bill 1036. They are not identical, but I don't want to put words in the senator's mouth, but I think he was comfortable with mine moving forward, and he's going to deal with his over in the House.
Okay.
Mr. Chair.
This is HB 2113, Senator McPike.
Yeah, so I've conformed my bill to Delegate Bulova's bill. This deals with the overall public procurement exemption, and I think Delegate Bulova has provided a little bit more elegant way to ensure that those with procurement exemptions have some structured framework and not just sort of an open free-for-all. To sum it up, but I think Delegate Bulova has done, a much more elegant job than my original version, which took it a little bit different angle. So,
Okay. Anything you want to add, Delegate Bulova? Okay. So did I hear a motion on that bill? Move to report. Okay. Second. Motion and second to report HB 2113. Please indicate your preference on the voting board. Okay.
Thank you, Mr. Chairman.
Then we come to Delegate Watts on HB 2122. I see a note that that this is with the version reported from House General Laws and their amendments, that it is identical to Senator McClellan's SB 1460 staff. Is that right? Okay. So this is the adding conflict of interest training for appointed school board members. Is there a motion on that? Second. Okay, moved and seconded to report. All in favor indicate your preference on the voting board, and as those against do the same. Okay. Now we've got Delegate Moorfield on universal license recognition with DPOR, identical to SB 1213 from Senator McDougal, which we passed unanimously.
Move report. Second.
Okay, there's a motion and second to report. Please indicate your preference on the voting board. Okay. Now we've got Delegate had HB 2312, which was identical to SB 1263 from Senator Hackworth, dealing with universal statewide building code, basically in a stop work order situation that was ruled erroneous. There's ability to recover costs. That bill passed this committee 14 yes with 1 abstention. Is there okay, there's a motion and a second to report HB 2312. Indicate your preference on the voting board. Okay, and that reports, with Senator Boysko's proxy. Okay. Thank you. Okay. Delegate Campbell, you had the Virginia Economic Development Partnership Authority on-site development grants lowering the acreage requirement from 100 acres to 50 acres, which was identical to SB 1308, Senator Deeds' bill. Is there a motion?
Move report.
Okay.
First bill before the committee, isn't it?
Is this your first bill here? Thank you for being here. Come on, you want to walk out on the plank and,
I'm not sure.
Yeah, and this one has to go to finance if it passes. Okay. I think we do want to pass this, to be fair. I think we want to help those smaller economic development sites.
Why?
Would you like to ask the patron a question?
You can tell us why.
I don't like this bill.
Okay.
I think Senator Stewart has 5 or 6 questions.
Senator Stewart, you had a question? Okay, his mic's been cut. Good choice over there. Okay, so was there a motion and a second to report that?
Move to report and refer.
Okay. Please indicate your preference on the voting board. To report and refer. Okay. Great, congratulations.
Thank you.
Okay. Now, Delegate Bennett Parker has HB 2371, which is identical to 942 from Senator Saslaw, with removing the requirement that members of the Alexandria Historical Restoration and Preservation Commission give a surety bond. And we passed that out of this committee, 13 yes with 1 abstention. Okay. And that one doesn't go to finance, does it? Okay, so there's a motion and a second to report that. Please indicate your preference on the voting board.
Ayes 14, no zero, 1 abstention.
Okay, next, Delegate Campbell, J.L. Campbell, had one in the Virginia Procurement Act identical to Senator Bell's 1491. This needs to be referred to finance if it's to pass, and I believe, Senator Bell, that yours was the product of a work group, is that right?
Yes, Mr. Chairman, and I believe this is the same as my bill. It's an absolutely amazing bill.
I tend to prefer the House version. So the motion was to report and refer to finance, and was there a second to that? Okay, and a second. Please indicate your preference on the voting board. Okay. Next is HB 1898 from Delegate McGuire. Delegate McGuire, are you here? This had to do with prohibition on companies boycotting Israel. I'm going to wait till Delegate McGuire is here till we hear that. I want him to be able to talk to it if he chooses to. Delegate Batten, the Treasury Board Power and Duties, HB 1912. This is similar to HB 1094 from Senator Norman. It's got to go to finance if it's to be reported. Do we know the differences between your bill and Senator Norman's bill?
Mr. Chairman, the intent is for them to be identical.
Okay, let's ask staff. It says here that they're similar. Are they now identical, or do they need to be conformed in some way? My notes said similar. Do you know if they had varied at one point?
They did vary at one point. There were multiple amendments that were made throughout the process. On the House side, those amendments were made both in general laws and then later on in appropriations.
Okay, so you're suggesting that yours is fine as is. Have you spoken to Senator Norman about that?
Mm-hmm. And if there's any conflicts, we can certainly send them to conference, but they should be identical at this point.
Senator Norman's bill contains technical amendments, so if you vote to conform her bill to it, it's just Roman numerals that need.
Oh, just fixing some numerals?
Move to conform.
Second.
Okay, so there's a motion and a second to conform HB 1912 to SB 1094. All in favor indicate by saying aye.
Aye.
Any opposed? Okay, so they're now conformed.
Move to report and refer to finance.
Second.
Okay, move to report and refer to finance. Please indicate your preference on the voting board. Okay.
Ayes 14, noes 1.
Thank you. Okay, then we've got.
Thank you, Mr. Chairman.
Thank you. Delegate Runyon. This is it's similar to Senator Peake's SB 976 about default by an occupant dealing with watercraft, allowing watercraft to be towed in lieu of conducting a public sale of the watercraft. Let's ask the staff, there are differences?
Thank you, Mr. Chairman. House Bill 2122 is identical to Senate Bill 1460. House General Laws reported it with amendments yesterday. That conforms it to the version before us.
Okay, the numbers I've got in my sheet say it's HB 1930, is that right? It says similar to SB 976. This was the bill allowing someone who had a storage unit in default to have a boat towed.
Thank you, Mr. Chairman. I'm sorry. The only difference is whether we're using this language of combined with versus as part of. I don't think that it makes a legal difference. It's just up to the committee.
Okay, Delegate Runyon, did you discuss this with Senator Peake as to whether you two had a preference?
Yes, I would. Senator Peake and I have agreed that my bill can be overlaid on top of his, so they would be identical. There's 3 words difference, and so that way the bill will go through both. It'll go through our chamber.
So in the House, you're going to conform his to yours. Okay. So there's a motion to report and a second. All in favor, please indicate by voting aye on the voting board. Okay. Now we've got Delegate Betsy Carr, HB 2046, Department of Housing and Community Development, powers of the Director, Statewide Affordable Housing Needs Assessment and Plan, which is similar to Senator Locke's bill that incorporated Senator McPike's and my bill. Is Delegate Carr here? Okay. Had she discussed it with you?
Not yet.
Okay. Why don't we wait and see if she comes by? Otherwise, we'll. Okay, we'll wait and see if she comes back. But okay. Next up is Delegate Byron has HB 2195, which I think has a substitute now. It's similar to Senator Ruff's SB 1470. Is there a substitute on that? Is Delegate Byron here? Okay. Secretary Slater, do you want to tell us the differences in the substitute that I understand had been prepared?
Yes, Mr. Chairman. Delegate Byron is in courts right now. But if I could, I want to take a minute to explain the substitute that you all have. Delegate Byron and I believe Senator Ruff and Senator Barker both are in agreement with the substitute. We've worked together with stakeholders and our friends in organized labor to come up with a bill that sets us up for success, we believe. The substitute does the following. It includes the Finance Committee definitions for workforce education and training program and workforce services program. It makes a technical amendment by striking adult education and family literacy from line 253, which was missed earlier. It includes the Finance Committee amendment by removing penalties for misdemeanors in relation to data sharing activities. It adds painting and painters to the trades covered by the language we added last time on registered apprenticeships, which organized labor requested and which we agreed to. It makes a technical amendment by inserting pregnancy, childbirth, or related medical conditions and military status to conform to the Virginia Human Rights Act. It adds the Finance Committee language on the Secretary of Labor working with the Office of Data Governance and Analytics to assess existing data systems. It adds the Finance Committee language on adding 2 members from the House and 2 members from the Senate to the Stakeholder Advisory Group. It adds the committee language that moves the completion date from to September of 2024 from June of 24, and adds the language on the Secretary of Labor providing updates. It adds the Finance Committee language on the Secretaries of Finance and Labor providing periodic updates to the House and Senate money committees. It does not include the Finance Committee language on the data sharing language for SHEV, as that language would potentially be more restrictive than the MOU that SHEV has already signed. It does not add the business engagement office section, although the new agency will engage in aggressive business outreach as part of their core mission to train to businesses' needs and involve business and training and curriculum development. Both organized labor and the administration support the non-inclusion of this section. And finally, it does not remove the Innovative Internship Fund program, known as VTOP, from the list of programs that would transition to the new agency. We've worked very hard to arrive at this compromise, and if this version can make it through the Senate without any further amendments, and I'll defer to Delegate Byron, I believe it will be able to pass the House as it is, and if it makes it to the governor's desk, I can say that there wouldn't be any amendments or changes.
Okay, so with that explanation, is there a motion to adopt the substitute?
So moved.
Okay. All in favor of adopting the substitute will say aye. Aye. Okay. And does this one need to go to finance?
Mr. Chair,
Okay. Yes, Senator Hashmi.
I might be a no on the substitute, but just wanted some clarification from the Secretary. Did I hear you correctly that VTOP is now back in this version? We had removed it from the Senate version, but it is back. The internship programs are back in this version?
The internship program is back in this version. It was in the version that came out of this committee. It was taken out at Senate Finance.
Mr. Chairman?
Yes, Senator Hashmi.
The Secretary, I was just curious if there was any opposition to putting the internship back into the program?
Opposition from organized labor?
From SHEV or any of our...
We've had discussions with SHEV. I think there was some hesitancy, but as I understand it, the director of SHEV is okay with this. You would have to ask him, but the conversations that he said he wanted to be a team player.
Thank you, Mr. Chair.
But if he's here, I'll ask him to come up and speak.
Senator Mason.
Thank you, Mr. Chairman. So, Mr. Secretary, thank you for taking us through the changes. Did I hear you say that you feel like with these changes, you'd like to see this be done and we're not making further adjustments as we move along?
If it's the will of this committee and the Senate and the House to adopt this version, the substitute, we'd be fine with it. I think everybody would be fine with it. And that there would be, we would recommend no changes, and learn how to put this right. Been told that if we recommend that this be it, that it would be it, and there would be no changes that would come after this.
Mr. Chairman.
Okay, I've got Senator McPike and McHugh, and then Senator Reeves.
Mr. Chairman, I just have a statement, then I'll have a motion after that. I just want to thank the Secretary for all his hard work, and those of us who do this daily understand the grind and the pressure you're on to get to a deal, and I appreciate what you're doing. I think it's going to benefit the Commonwealth greatly. It's going to move us forward, and I appreciate you all you've done. And with that, I'd make the motion to pass the bill and refer to finance when it's appropriate.
Okay, so we have a motion, but I'm going to recognize people who want to speak to the motion first, starting with Senator McPike and then Senator Locke.
Thank you, Mr. Chair. Just speaking to the motion briefly, and I also wanted to give my appreciation to the Secretary for working with stakeholders. This has been a really big bill, and a lot of different parties have been concerned, and I know you and your team have been doing just coming and trying to update and work with partners and making sure concerns have been addressed, and I see the evidence that you've done that, and so I really appreciate you listening and not just saying, here's what it is and take it or leave it, and really working to build some partnerships, which I think helps, and hopefully that continues. But agreed, hopefully no more significant changes, and we're good to go. Thank you.
Takes both branches to get a bill passed.
Senator Locke.
Thank you for that update on what has occurred with the bill. I'm disappointed that VTOP was moved back in and away from SHEV. And my question has to do with adult education. Where is that now?
Adult education, Mr. Chairman, adult education would remain at the Department of Education. One of the things that we have said with regard to the VTOP program is understand the importance of the coordination with SHEV and with the universities. So one of the agreements that we've made is that we will detail some people back to SHEV to make sure that there's a continuity stream between the new department, people working with the department at SHEV who are working directly with the provosts and the universities to make sure that there's a constant line of communication between all three. But the short answer to your question is Department of Higher Ed and it stays at the Department of Education.
We've got a motion and a second. Is there any other comment from members of the committee before we proceed to vote? Okay, so this vote is to refer to...
Mr. Chair.
Yeah, Senator Rouse.
Thank you. Question for the patron.
Well, for the secretary.
Secretary. Patron. Thank you, Mr. Secretary. Where is organized labor in support of the changes you have made? I'd like to hear from them.
Organized labor, I believe, is here. I will defer to the president.
Welcome, Ms. Grasmace.
Thank you. Yes, Mr. Chairman and members of the committee, I want to commend the Secretary for working with us on the issues and things that was of concern to us. So we greatly appreciate all of the work and everything was put in that we were working for. Thank you.
Thank you. Okay. We had a motion and a second to report. Please indicate your preference on the voting board. That's report and refer, I should say. Okay.
Ayes 12, noes 2, 1 abstention.
Okay. Delegate Carr is here. You had a bill that was similar to Senator Locke's bill on a housing assessment. Okay. Do you, we were going to conform your bill to hers unless you can.
Fine.
Is that, okay. I didn't want to do that without your being here first.
Thank you.
Okay. So that's HB 2046. So the motion would be to conform HB 2046 to SB 839 on the housing assessment needs assessment. Okay. All in favor, please say aye. Okay. Any opposed? Okay. So then I would entertain a motion.
And we refer to finance.
Okay, report and refer to finance. All in favor indicate your preference on the voting board and opposed to the same.
Ayes 15, noes 0.
Okay, and while you're there, did you have any other bills before us today?
Yes, sir. I had HB 1738, which concerns virtual public access.
Okay, do you want to explain? This
Yes,
is
sir.
a bill that we had not heard before.
Yes,
So
there's
do you
no
want to explain
Senate
that for us?
companion. Yes, sir. This is just, 1738 ensures virtual public access for public meetings of state and local bodies. It is permissive, and it clarifies that legal action cannot be brought if the electronic connection is dropped. In other words, if I'm listening and something happens and I lose connection, then I can't bring suit.
Okay, are there questions for the patron? Is there anyone in the audience who'd like to speak in support of this legislation? Anyone in the audience who'd like to speak against it? Okay. There's a motion to report and a second. Please indicate your preference on the voting board. Okay. Thank you. Now, I see Delegate Bennett Parker's been waiting. You had a, oh, you have another bill?
Yes, sir.
Oh, okay, one second.
We had the fire.
Defining Fire Company, 1765.
This was brought to me by a fire rehabilitation company, and this is just they would like to be termed a fire company, so that they can have a license on their truck and so forth. There are no fiscal implications for the city. It was supported by the fire chiefs and so forth. What these rehabilitation companies do is provide food, water for firefighters. They don't fight the fire themselves, but they bring and support the firefighters. And if it's cold, they provide warmth. If it's hot, they provide coal. They provide cleansing stations and so forth.
Okay, so we would be adding firefighter support organizations to fire companies in that definition.
Yes, sir.
Are there any questions for Delegate Carr? Okay. We have a motion. Is there anyone in the audience who feels compelled to speak for or against this? Okay, so we will indicate our preference on the voting board on HB 1765.
Thank you very much, Mr. Chairman, members of the committee.
Thank you.
Ayes 15, no zero.
Next, we're going to take Delegate Bennett Parker, who's been waiting, and
Thank you, Mr. Chair. This is House Bill 1857, which is identical to Senator Bell's Senate Bill 1249, which passed the Senate unanimously after going through the Commerce Committee. It's a consumer protection bill to address deceptive event ticketing websites. I'd be happy to answer any questions.
okay, there's a motion, a second, to report this bill, which is identical. And does this need to go to finance, or does it go to? Okay, so or does it go straight to the floor? Okay, straight to the floor. Okay, so please indicate your preference on the voting board. Okay.
Ayes 15, no zero.
Okay. Let's see. Where was docket? Oh, was that identical as well? Was her similar? Was her bill identical as well? The other bill?
2371. 2371.
2371, identical to 942. Yeah, it's already good to go, right?
Did we already pass? Let's see, which page is that on?
No page number. Page 3.
No, we took that one up on the Alexandria bonds for the Historic Restoration and Preservation Commission. It was same as Sasla. We took that up.
We've already reported it.
Okay, thank you. So I've got, have we done all the identical bills? Yeah, we started. We're on the similar ones. Okay. So I've next got from Delegate Wampler, the Common Interest Communities Resale Disclosure Act, which was similar to Senator Mason's SB 1222. Senator, is Delegate Wampler here? Okay, Senator Mason, have you discussed with Delegate Wampler the differences in your bills? Do you know what the history?
Yes. Yesterday, we put some amendments on in House General Laws, and one of them had a little typo in it even after we did the amendments. So I don't know if our team has the amendments we did yesterday with the one change where I think it said enactment, we needed to say act, the last one. Can we, so conform his to me and then make that amendment? Thank you, ma'am. Sorry, Mr. Chairman, I had to get to the brains behind the operation there. So why don't we conform Delegate Wampler's bill to mine?
Okay, so that'll be,
So I move
is there a
that.
second to that motion? Second. Okay, so let's conform HB 2235 to SB 1222 first. All in favor, please indicate by saying yes.
Aye. And Mr. Chairman, I believe the last amendment said enactment, and we meant it to say act. That's what it's supposed to say.
Okay, so then we're going to make that
So-
one-word amendment.
So, Mr. Chairman, so now I'd like to move the amendments.
Okay, motion to, move the amendments plural?
We did it.
Okay. So all in favor of adopting those amendments will say aye.
Aye.
Any opposed? Okay.
And Mr. Chairman, that should have them identical, and I will follow up and make sure that that is the case, but they should be identical now.
Okay, now we can entertain a motion to report.
Move to report.
Okay. There's a motion, a second, to report HB 2235, this, as amended or substituted. Please indicate your preference on the voting board. Okay. Before we move further, thank you. She should not
Ayes
give her
15, no
proxy.
0.
I know that Delegate Sullivan was going to present another delegate's bill. I think it was Delegate Willett who was under the weather. Not yet. Did you want to go ahead?
Yes, thank you, Mr. Chairman. Delegate Willett is out, and since there's no remote option here, he made the fateful and hopefully not fatal decision to ask me to present his bill. This is HB 1748, Mr. Chair.
Okay. Why don't you tell us about it?
Sure. What the bill does is two things. It updates the code section. This all relates to professional solicitors, people out raising money. It does two things. It updates it in terms of modernizing it, and by that I simply mean it adds email to the type of solicitation that's covered by it. And then it also addresses what I would think is a consumer protection issue. This came to Delegate Willett's attention from some PTAs who often will hire professional solicitors to help them raise money. Apparently it is all too frequent that the percentage of the raise grows and grows and grows unbeknownst to in this case, the PTAs. So what this bill does is, I said, it adds email, and then it makes certain requirements of the contracts between a professional solicitor and whatever nonprofit organization it happens to be contracting with. It makes clear that the contract either has to specify what the percentage take will be, or if it provides simply a method of doing that, it will provide enough information that the PTA or nonprofit will be able to figure out exactly what it's going to cost them to do this. And that, as I understand it, is the bill, Mr. Chair.
And I believe that reported unanimously from the House.
Is that a good thing?
I think that's a good thing.
Okay, just want to make sure. There are committees where that's not a good thing.
Well, are there questions for Delegate Sullivan? Okay. Is there anyone in the audience who would like to speak on this particular bill? Okay. There's a motion, and is there a second to report HB 1748? Please indicate your preference on the voting board.
Ayes 14, noes 1.
Okay.
Now, Delegate Sullivan, you had a bill yourself on real estate agent settlement fees. Is that right?
I did. Thank you, Mr. Chair. This is HB 1888, and a couple of questions came up as it was coming out of the House. There is a substitute which is available, I hope.
There's a motion, a second, to adopt the substitute. All in favor, please say aye.
Aye. Thank you, Mr. Chair. While this is being distributed, I'll describe the bill. It's really just an effort to clarify who pays what fees in a real estate closing when the seller is represented by counsel. And what it does, Mr. Chair and members of the committee, is simply requires notice to the seller's counsel from the settlement agency, notifying them, specifying, and asking for consent if they're going to be charging the seller any money. It doesn't slow anything down. It's not time-consuming. It simply protects sellers from having fees show up that they did not know about. And the bill makes clear that written consent from the seller's lawyer, this only applies if the seller has a lawyer, is required before the settlement agency or any of its subsidiaries or affiliates are going to be charging the seller fees.
Okay. Were the realtors or other organizations speaking on this in the
yes, sir. Yes, sir.
Thank you, Mr. Chair. Erin Corman with the Realtors. We do support this bill. This is an issue that our members have been bringing to us since the letter from the BOI went out last year. There's been a lot of confusion, and we're hoping this is a step in the right direction to clarify things.
Thank you. Okay. Any questions from members of the committee? If not, we can entertain a motion. Okay. Motion and second to report HB 1888. Please indicate your preference on the voting board.
Ayes 15, no 0.
Thank you, Mr. Chair and members of the committee.
Thank you. Okay, we're going to move to the queue. I see there's a lot of people have signed up, starting with Delegate Fowler.
Mr. Chairman.
Senator Reeves.
Delegate Fowler has almost an identical bill that I had that was taking the lottery has a fund and they needed an additional fund, so they weren't putting casino and sports betting into their same silo of money. There's, I think, one difference in I'll probably wind up conforming mine in the House to Delegate Fowler's, I think, but I'll let him speak.
You prefer this version?
Mr. Chairman, I believe, it's my understanding after I just left the House Finance, that currently my bill is in, we're conformed right now.
Okay, perfect.
Yep.
Okay.
Yep.
Move to report and refer to finance.
Okay, there's a motion to report and re-refer to finance. Please indicate your preference on the voting board.
Ayes 14, noes 1.
Thank you.
Thank you, Mr. Chairman.
Okay,
Members
Delegate
committee.
Bulova, I apologize. We didn't conclude your business. You've got HB 1635, the Residential Tenant Landlord Act Uninhabitable Dwelling Unit Bill.
Yep, thank you, Mr. Chairman. So this is House Bill 1865, deals with situations when a tenant accepts the keys to a rental unit and finds it doesn't meet basic habitability standards right off the bat. The habitability standards that you see in the bill, these have actually been worked on with stakeholders in the General Assembly for a number of years. It's the same language as other parts of the code and includes things like rodent infestations, lack of heat, lack of adequate sewage disposal facilities, and things like that. So when things happen like that and you walk in and you realize that you don't have a habitable unit, this bill just establishes a process for the tenant to get out of that lease and to get their deposit back if they provide written notice to the landlord within 7 days. It also provides a process for the landlord to assert back that it is indeed habitable, and if there's a disagreement, but the tenant can go ahead and has the option to go ahead and file in a court of competent jurisdiction. It is actually a growing issue as more people move into rental units sight unseen. And so I do have some good examples if you'd like them. But for instance, Facebook Marketplace, people will see the pictures online. They'll go ahead and sign up for a lease. They'll wind up going down and want to move into the unit and discover that it is uninhabitable, and then they're kind of stuck. So it's just a matter of, if you get a rental unit, you've got a basic expectation that it's going to meet habitability standards, kind of like a lemon law for cars, right? So when you drive it off the lot, should at least work for a couple days, and if not, you go ahead and get your money back. I do want to thank the stakeholders for working on this with me. They worked really hard, so that's the Virginia Poverty Law Center, Realtors, AOBA, the Virginia Apartment Managers Association, and I believe we got Peace in the Valley, Mr. Chairman.
Okay, is there any stakeholder who wants to comment further? Your support has been noted. Anyone particularly opposed to the bill or any other comments? Okay. We've got a question from Senator Stewart.
Thank you, Mr. Chairman. David, so would this apply if you rented a room in your house to somebody? Or is this just to the landlords that have more than 4 units?
Yeah, I believe this is just for landlords with, is it?
I don't think it is.
I don't think we didn't make that distinction.
Did
no.
you intend to have it apply to, a citizen who rents a room to a school teacher or something?
The bill refers to a rental dwelling unit. I don't know if anyone can tell us if that's defined in the code. Okay, we're checking on that.
Yeah.
Okay.
And I guess depending on the answer, even if it was, a room in my house, if I moved into it and found that it was rat infested or didn't have working toilets, probably the least that you could expect is to get be able to break that lease and get your deposit back. So I don't know that that's a huge deal for even the small mom and pops that you'd expect it to be habitable.
Mr. Chairman.
Senator Stewart.
The only concern I have is that some of those folks are unsophisticated and they don't know how to play by these rules because they're not even aware that they're out there.
Yeah, and I guess, Mr. Chairman, the only recourse you'd have is you'd be able to break the lease and get your money back. So.
Okay. Yeah, this is referring to serious threat to life, health, or safety of the tenants or occupants of the premises, like infestation of rodents or lack of heat, cold, or running water, electricity, or adequate sewage disposal. Okay, are there other questions? Okay. Is there any other motions? Move to report in a second to HB 1635. Please indicate your preference on the voting board.
Ayes 14, noes 1.
Okay, thank you. You had one more bill as well?
I got one more that you're going to have a lot more fun with. Mr. Chairman, this is House Bill 2098. This is a bill that deals with common interest communities. And actually, I had mentioned the fact that I was carrying such a bill to one of our new members. She was here for no less than 3 weeks on the job, and she looked at me with a very puzzled expression saying, "I thought I was told that you should never introduce an animal bill or an HOA bill." So I will say, I think it's safe to say that people have strong opinions one way or another about HOAs. Some people love them, some people not so much. But either way, the General Assembly and kind of our ultimate wisdom has decided to set out rules and standards for common interest communities. And so we do have a responsibility to make sure that these common interest communities can function properly. And that's really kind of the core of what this bill is getting at. And so what this bill does is twofold. So it brings some better consistency and due process to enforcement by common interest communities. And it also fixes a very specific problem that makes it difficult to deal with repeat violations. And so regarding the first item, would just draw your attention to lines 24 through 27. And that just makes it clear that all associations have the authority to ensure compliance with association rules by being able to impose very modest penalties. And so the reason why that is so important is that if you don't have that ability, the fallback is that you got to go to court. And going to court can be extraordinarily expensive and time-consuming for all parties involved. And so what this does is make sure that you've got that due process that we have in place that you can go through. And so you get notice, you get a hearing, you got an opportunity to go ahead and correct before a penalty. And so this just makes sure that all associations are able to play by those rules. The second part that we're trying to fix in terms of that problem was brought to my attention by a condo association in my district, but apparently it's something that is a bigger problem. And so let me just lay out the issue. The way the current code reads, a person in violation of the rules, they're given notice, they're given a reasonable opportunity to correct the violation, and then only if the violation remains uncorrected is there a hearing, in which case a person can state their case, and only after that can the HOA impose a penalty up to $50. And so that works really, really well for something like painting your house the wrong color or something along those lines. So you're given a chance to paint it the right color, and if you do it, no harm, no foul. The problem is, let's say you get busted for a noisy party, or you leave trash in the common area, or you engage in disruptive behavior at the pool. As soon as you stop that party, as soon as you pick up that trash, as soon as you stop that disruptive behavior, you have corrected the problem. And since it's corrected, at least the logic in the code, there is no next step. And so unfortunately, you do have bad neighbors every once in a while who will have these repeat violations. And what the astute lawyers in this condo association realized is that they were trapped because, again, as soon as they stopped that noisy party, as soon as they picked up that trash, they couldn't find those individuals. And so that's where the language in lines 43 through 45 comes in. It says if a member of the association has already gone through the entire process and then repeats that same violation within a 12-month period, the association provides notice, but they can go ahead and take action. While they didn't have a position on the bill, DPOR was kind enough to approach me to help work on this language, and they felt comfortable to make sure that there was due process involved. So, Mr. Chairman, thank you very much for the opportunity to present the bill, and happy to answer any questions.
Mr. Chair.
Yes, Senator Boyce, go.
Thank you, Mr. Chair. Delegate Bulova, if there is an HOA and some residents who have a long-standing disagreement and it's become a personal thing, is there a remedy set forth in this that could be?
Senator Boysko, I'm not sure that you can ever solve through a fine a personal grudge that goes back and forth. It's really very much focused on just very tangible violations of your rules and responsibilities. Doesn't get into the business of just disagreeing with one another.
Just to follow up, so just to clarify, you're really looking at like people throwing their trash out on the ground, making too much noise, real quality of life annoyances that the HOA does not have the ability to really enforce at this point.
Correct,
Is that
Senator.
correct?
Correct,
Thank you
yes.
very much for the clarification.
Are there people in the real estate or common interest community who wanted to comment on this bill?
Mr. Chairman, I have a question.
Okay, we'll get your question next then. Okay. Why don't you come forward and then we'll get Senator Bell's question.
Good afternoon, Mr. Chairman. Pia Trigiani. I'm here on behalf of Community Associations Institute, which is a membership organization of homeowners, communities, associations, and those who work with them. And I have the same love-hate relationship that many of you have with the homeowners association. So I completely understand the concerns. But I'm here to rise in support of the bill and thank Delegate Bulova for bringing the bill. Gave us an opportunity to discuss it during the Housing Commission work group, which he chairs. This gives an opportunity for associations which take significant burdens off of localities. These community associations exist because they provide services, amenities that traditionally were provided by localities, counties, cities, and towns. And they need the same ability to address rule compliance issues with individuals. We like to think of it as not disenfranchising or dealing with a bad neighbor in support of the good neighbors. Many good neighbors are threatened by conduct of their neighbors. It may affect their ability to enjoy their homes, and so it's important to have an opportunity at the most local level, internal to the association, to try and work through those issues, and that's what this does. Notice and an opportunity to cure, notice in a hearing before any action can be taken. And it levels the playing field between all community associations. Many have this authority in their recorded governing documents, but many older do not. We have a number of people here who experience this on a daily basis in their own communities and are glad to speak in support of the bill. And I'm glad to answer any questions, Mr. Chairman.
Thank you. Okay, Senator Bell, did you want to ask a question before we hear from other witnesses?
My question's for the patron. Kind of takes me back to a personal experience. We received a violation in my neighborhood from the HOA once saying that the front door was faded, but the picture of the house provided wasn't my house. And come to find out, many of my neighbors got the same notice. Somebody didn't know how to use mail merge quite right. So reading in the code, and the part of this is existing code, but I think what you're changing impacts this. There is provisions in the existing code, I think line 46 area, where we're talking about alleged violations and then new violations, so which starts on 42. So my question really is, when we talk about alleged violations, sorry, that's line 32 on alleged violations. When we count new violations, are those alleged violations going to count or not, or they would only count if they've been validated as something that was actually real?
validated as real. That's the due process part of this.
Mr. Chair.
Senator Bell.
I agree. I'm sure that's the intention, but the way I'm reading it, I guess I want to ask counsel if they think that it reads like that.
So which line, or counsel?
Okay, because it talks about the reasonable violation, correct the alleged violation on line 32, and then we go down to talk about repeat violations. So my concern is that an alleged violation, just because it was alleged, wouldn't go on that record that could count as a repeat later on. Does that make sense what I'm explaining?
Thank you, Mr. Chairman and Senator Bell. Yeah, I think that I am following what you're looking at, but I do think that Delegate Bulova is correct. I think that although we are referring to an alleged violation on line 32, because we are more specifically referring to a violation continuing or occurring again on line 34, I think that the due process comes in when we are giving a reasonable opportunity to correct that violation. So I think that's where the due process is before the, is if they make that correction. And then if they violate that again, I think that original correction would have been the due process for that, if that makes sense. But please let me know if I wasn't clear, though. Thank you.
I think that satisfies my question. So you're basically saying the due process would ensure that alleged violations are validated before they're considered repeat.
Yes, that is my understanding. Thank you.
I guess I just throw that out there. Is this something we need to clarify? Because, I'm still not getting a warm fuzzy that we're not going to count this against people.
Yeah, and Mr. Chairman and Senator, I guess I would rely on council's reading for that. I'm not sure how we could fix that on the fly. If it ends up still being a concern, we can always tighten that up, but I would rely on counsel in terms of her reading of what the plain language says.
Okay, thank you. Okay, were there others who want to speak to this bill?
Mr. Chair, I have a question.
Senator Rouse.
Thank you. I have a lot of constituents in my district who live in HOAs. I'm sure there's many other committee members as well. My concern is for our seniors and those who are on a fixed income, who have, and we've seen as of lately, HOA fees are continuously going up while incomes, especially our seniors, are on a fixed income. And some who are disabled, who aren't all the time able to fix their properties or maintain the HOA level of compliance. Now, if they are in violation of that, and they have, say, for example, they may have the only pool in their family, in their HOA, would this restrict their families and even themselves from visiting the facilities? And would this type of piece of legislation, will it continuously add on more fees or be more restrictive if they are already in, say, arrears from just not being able to make the fees from HOA prices going up?
And so, Mr. Chairman, I think Ms. Trigiani can probably provide a little bit more detail to it, but the way it's designed is that it's $50 per violation, and so there's defined caps on it. I guess, to one of the original points that I made is that the alternative to having a small fine like that is to take a person to court, which is going to take thousands and thousands of dollars. And so again, this is a way to make sure that you're internalizing these kind of issues within the HOA and that you're not having to go to a court in order to go ahead and resolve those issues.
But just to be clear, this does not add fees. It just adds an action for people who perhaps don't pay their fees or engage in other behaviors against the rules.
Sure, Mr. Chairman, this doesn't touch the fee structure that's already in the underlying bill.
Okay, Senator Rouse, does that complete your questions, or do you have another?
No, I have another question. Doesn't make me feel better about the bill, but I don't have any more questions. Thank you.
No more questions. Okay. Were there others who are waiting to testify? Please come forward.
Good afternoon, Mr. Chair and members of the committee. I apologize for my voice. I'm sorry. I hope you can hear me. My name is Deborah Carter, and I am the general manager of an HOA in Prince William County that has 1,533 homes and annual assessments of $1.8 million. I've been managing communities for over 30 years, so I've seen a lot. I've done high rises, condos, and I've been at this HOA now for 16 years. The bill that you're considering would be very beneficial to the HOA that I manage as well as others, and it would better enable the association to address compliance matters, as Ms. Tragiani said, on a community level. Speaking on behalf of the association that I represent, I first want to state that the primary objective for rules enforcement is compliance. That is what we're after. We're not trying to get more money from people. We're not trying to, penalize them. We want to get compliance. That's what we want. And in the majority of instances, compliance is attained by first sending someone a letter pointing out to them what the problem is and how they can address it. But the bill you're considering is intended to address the minority of homeowners who, for whatever reason, persistently or egregiously violate the rules. Presently, under the current statute, absent express authority in the governing documents, associations are limited in their ability to ensure compliance with rules that are foundation and essential to protect all of the residents of the community. The association that I manage is fortunate that our documents contain authority for the association to take action to encourage compliance, such as action to suspend use of association facilities and services. Suspension of parking privileges, for example, has proven to be extremely effective in encouraging compliance. Without that, or the authority to assess monetary charges for covenants violations, there's little recourse at the association level for violations that occur in the single-family homes.
Okay. We need you to wrap it up if you could, if there's any more points you want to make in summary.
Well, can I share an example with you?
Please, briefly.
Okay, we have a homeowner that in a single-family home that performed work on his lot and the adjacent common area that changed the grade and impacted the stormwater drainage, resulting in damage to the common area and to a neighboring lot. The work was performed without association approval and in violation of the county permit that the owner obtained. There were numerous other violations on the lot, and this situation began in 2020, and initially, I had an informal conversation with the owner, explained the procedures, which he ignored. Then we initiated the due process procedure. We sent numerous letters. We had numerous hearings for each violation. The homeowner did not attend the hearings, and the committee's decision to suspend use of amenities resulted in the homeowner erecting an above-ground pool in his backyard, which constituted yet another violation. Meanwhile, we're hearing complaints from owners throughout the community, not even just the adjacent neighbors, but throughout the community about the condition of this lot and asking why aren't we doing anything about it. So finally, the board had no choice but to file suit against this homeowner, which has been very time-consuming, it's been expensive, and potentially divisive.
Thank you.
Yeah. So.
Thank you. Thank you for being here. Okay, thanks, Ms. Carter. Okay, were there others? We're going to try and wrap this up. We've got a number of patrons waiting.
Yes, Mr. Chairman and committee, I'm Don Boswell. Been on the board of Twin Hickory Association in Western Henrico for 6 years, and I'll just be brief. I'd like to speak in favor of this bill. It's something that we need to protect the homeowners that do follow the guidelines and the rules of the association. There's only a handful of people that do this. This is not a money-making thing. We have almost $1.5 million in assessments. Last year, we only had $8,500 in monetary fines for the people, not fines, but monetary penalties for people that were repeat offenders or didn't come into compliance. So I'd like to speak in favor of the bill on behalf of the volunteer home board leaders.
Thank you. Okay, and I see one other witness here.
Hi, thank you for allowing me to speak. I will be brief, as most of the colleagues before me have said what I was going to say. But I would like to just say, my name is Dave Coyle. I'm a resident of Fairfax County. I'm the general manager of Cascades Community Association, which is a large-scale community in Loudoun and Fairfax counties of about 6,000 homes, 6,600 homes, 15,000 residents. I stand in support of this bill as it would greatly help the daily operations of a community association to encourage people to participate in a peaceful resolution of a potential property issue without trying to go to court. The one thing I would like to add is when you start taking people to court, those lawsuits are added to every resale disclosure. And I am getting more and more lenders and mortgage companies calling me asking why this is on here. So anytime we are not trying to take people to court, we do not want to take people to court. We don't even want to fine people. Out of a $6.2 million budget I have, we budget $3,000 in compliance issues. We just want people to be able to follow the rules and regulations because, as Debbie said, homeowners are calling repeatedly saying, why isn't the association doing anything? And we are just running around rampant, sending carefully worded letters and trying to get people to comply and, again, encourage compliance of all the rules and regulations.
Thank you.
Thank you very much.
Thank you very much. Okay. Is there any other discussion or motions from members of the committee?
Mr. Chair, I have a motion.
Sarah Boysko.
Having worked at the county level and with a number of HOAs, I understand that there are gaps where the HOAs just cannot take action on something. I think this would help, and so I move that we report the bill.
Is there a second? Second. Okay, there's a motion, a second to report HB 2098. All in favor indicate your preference, and those opposed to the same on the voting board.
Ayes 8, no 7.
Okay, thank you.
Mr. Chairman, you all have been very generous with your time, and I appreciate it.
Thank you, Delegate. Okay, now let's try and move through some of these. We've got Delegate Cherry. Which bill is that? Let's see. I don't know if Delegate Cherry's still here. Delegate.
You want to pick up Quinn there?
Well, no, we have a sign-up sheet. We've got Wiley is next.
Good afternoon, Mr. Chairman. I have HB 2500 in front of you. It has a substitute. It's been submitted.
Okay.
In the intended.
Is there a motion and a second to adopt a substitute to HB 2500? Okay. All in favor of adopting a substitute will indicate by saying aye. Aye. Any opposed? Okay. So this bill, if it's successful, will go to finance. If you can distribute the substitute, Delegate, please tell us about it.
Yeah, the substitute is going to be identical to Senator Bell's bill to make it perfect. So that's.
Is this the one that came out of the work group?
Correct. Yes, sir. From SB 550 last year.
Mr. Chairman. So this is now identical to what left this committee?
Correct. Mr. Chairman, this actually puts it in, we had a couple of minor DGS amendments, and this reflects the most current. It's in full agreement with my bill, which is in the same posture in the House now. And I would recommend we approve and report this fine bill.
Okay, I'm going to take that as a motion. Is there a second? Okay. All in favor, indicate your preference on the voting board, and those opposed do the same. Is it report and refer to finance? Okay.
No, sir.
They've asked for it.
2,500's on the list.
Yeah, this needs to go to finance. Okay. Okay. Thank you. Was that your only bill?
That's it.
Okay. So let's go to Delegate McGuire.
Thank you, sir.
Mr. Chair, members of the committee, I'm here to present House Bill 1898. It's a Virginia Public Procurement Act prohibition on boycotting Israel, civil penalty. I met a woman named Lorna, a Jewish woman, a couple of years ago, and she told me about discrimination with regard to BDS, the Boycott, Divest, Sanction Israel movement. Yeah. And I promised her I'd put a bill in. So last year I put that bill in, and folks on both sides came to me and said it wasn't ready for prime time. So I pulled that bill last year, and I worked all summer with lots of different groups And we ended up with support from organizations that make up almost 200,000 Jewish Virginians. Some of those organizations are the Anti-Defamation League, the American Jewish Committee, Jewish Federation of North America, Counter and Anti-Semitism Movement, Stand With Us, Christians United for Israel, United Jewish Federation of Tidewater, Jewish Community Relations Council of Tidewater, Richmond and Greater Washington, United Jewish Community of the Virginia Peninsula, the Conference of Presidents of Jewish Federation, and the Coalition Against Anti-Semitism.
Thank you. We heard a similar bill from Senator Vogel. This bill requires those public bodies that contract in excess of $100,000 with a business that employs more than 10 people to get a statement that they don't boycott Israel. Is that basically what it does?
Yeah, it's an anti-discrimination bill. I think if you subtract Jewish people with any other kind of people, we'd all see that that type of discrimination and boycott is, especially today, is not good.
Okay. Are there members of the committee with any new questions about this bill that we've heard? Similar legislation.
This is PBI 96.
Yeah. Is there? If there are no questions for the delegate, is there a motion?
Substitute PBI.
Second.
The superior motion was to PBI, so we'll vote first on whether or not to PBI HB 1898. Please indicate your preference.
Ayes 9, no 6.
Thank you, Mr. Chair. Members of
Thank
the
you,
committee.
Delegate. Okay, next up, I believe we have Delegate. Did we have Delegate Cherry already? I don't. Okay, Delegate O'Quinn. Hi, how are you?
I'm good. How are you, Mr. Chairman?
Good, thank you.
I have House Bill 2451.
Okay, so HB 2451. And if successful, this bill will be reported and referred to Finance, dealing with firefighters and electric vehicle fires.
Yes, sir, Mr. Chairman. So this bill was actually brought to me by a group of volunteer firefighters and then separately by a group of professional firefighters. And essentially this bill requires Department of Fire programs to develop a training program on the risks, tactics, methods, how you suppress fires in electric vehicles and how to safely and effectively manage those fires. It's to be completed by all firefighters in Virginia by December 1, 2025. And I do have a amendment on the House side in the budget.
Okay. Is there anyone from Department of Fire Services here today in support of this bill or wanted to comment on it? Please come forward. And if I could ask you, sir, do we do this? Do we require training for other types of fires in the code? Is that?
Yes, Mr. Chair. Spencer Willett with the Department of Fire Programs. So we do require training on Firefighter 1 and Firefighter 2 is required in the code for firefighters. That training encompasses vehicle fires, conventional vehicle fires, structure fires, all types. There's limited discussion about electric vehicle or alternative vehicle fires in that training. And we do see this as a more prevalent issue now with the more electric vehicles on the road. So we are supportive of the legislation from the delegates.
So kind of an update.
Yes, sir.
Mr. Chairman.
Okay, Senator Reeves.
Before he leaves the lectern, can't you make this distant learning? I heard from some of my fire folks, and they were concerned that this is more time away and everything else, and they do, I guess, some remedial training or their annual training. A lot of it's done online. Is there an option for them to do that?
Yes, sir. Actually, the three options that our agency gave to the Department of Planning and Budget that would suffice for the bill would also, we have three options. You can do an in-person actual course, or there's also a virtual option as well.
Can you show me where that is in this bill?
Senator Reeves.
Thank you. I'm sorry, Mr. Chairman.
I'm not sure if it's in the.
It says a training program. It doesn't specify whether it be online or in person. Do you interpret that if this passes to give you that option?
Mr. Chair, we would interpret that would give us the option. The agency's plans would be to offer an online version for departments and then also offer an in-person version for those that would be willing to want to take that training additionally.
Thank you. Thank you, Mr. Chairman. Thank you.
Okay. Are there any other questions for our witness or for Delegate O'Quinn? Okay. There's a motion and a second to report HB 2451 as and refer to, is it that one you have, is that on the list? Okay, and refer to finance.
Fisk, right?
Okay, so this would go to finance. Okay, so please indicate your preference on the voting board.
Ayes 15, no zero.
Okay, then we had Delegate Price.
Thank you, Mr. Chairman and members. I have House Bill 2441.
2441, and is that bill have a substitute? Senator Bell, did you have a substitute?
Mr. Chairman, I do have a substitute. I've talked to the patron, and I think we have peace in the valley on this.
Okay, let's distribute the substitute while we hear a motion to adopt it. Okay, all in favor of adopting the substitute? Please. That's okay with you, right?
Yes.
Okay, please indicate by saying aye. Any opposed? Okay, Delegate Price, if you could fill us in.
Yes, thank you, Mr. Chair and members. So basically, on the last day that we could file bills, I was made aware of a situation where an entire complex in Newport News had been shifted to month-to-month leases and then given 30 days notice that they had to vacate the premises. There were veterans, elderly, families with small children, and they, in 30 days, were having to find a new place. As some of you may know that's going on in your areas, our social services departments are already overrun, helping families that are experiencing homelessness and being unhoused right now. So an influx of 100 people at a time, Newport News Social Services just could not keep up. So what this bill would do, as substituted, it lays out some parameters, but for 20 or more, or 50% or more, not termination, we changed that, but termination of month-to-month leases, there would have to be 60 days notice. And the intent here is to give more time for the social services departments and the residents to find a new home. There was a 22-year-old resident in the link that I sent you all for the article on this. 22 years he had been living there, and he was given 30 days notice to pick up and move. So this would just help those situations.
So this gives notice only in large-scale displacements where people are being terminated or month-to-month with short notice?
Yes, this has nothing to do with the residents that want a month-to-month lease. This is when the owner chooses not to renew the contract or the lease.
Yes, Senator Stewart.
Thank you, Mr. Chairman. Delegate, as I read this, it says notwithstanding the provisions of subsection A. So you could enter into a lease and sign and agree to a different time frame, but then this paragraph would then supersede what you agreed to. Am I reading this correctly?
I am still looking at the substitute, notwithstanding. Yes. And that would again be for 20, the greater of 20 or more, or 50%.
Mr. Chairman?
Senator Stewart.
But under subsection A, you can write your own terms, and you agree to those terms with the landlord. But then you can avail yourself of subsection B, even though you had a written contract. That's how I understand it.
Only in a large scale, if there's 20, is that correct?
Yes, so it wouldn't be just the one-on-one lease between the owner, Mr. Chairman. It would not be the one-on-one lease between the one unit and the owner. It would be upon the owner, should they be doing that with 20, the greater of 20 or more, or 50% of the units. The one-on-one conversation, the tenant may not even know what the owner is doing, much like the situation in Newport News. So this is saying, if you know that, a lot of the owners who are selling their properties or shutting down their properties in order to renovate, they know that well before 60 days that that's going to happen. So it's asking the owner, if you know that and you're going to do that to the tune of these numbers or more, that you would offer 60 days notice.
Mr. Chairman.
Senator Bell.
I would just add on this would only apply to month. So you wouldn't be changing the terms of every contract, just it would apply to month.
Mr. Chairman.
Senator Stewart.
Could I just ask staff if they believe this is constitutional? It's an abrogation of contract as I see it.
Thank you, Mr. Chairman. Senator Stewart, I'm sorry, I don't have an answer to that right now, but if you would like for me to look into the issue further, I could certainly prepare an answer for you prior to the floor.
We might all know that before we vote on it, Mr. Chairman.
Okay, if you could research that further and get back to Senator Stewart and me. Now, are there other questions from members of the committee? Are there witnesses in support of this legislation?
Thank you, Mr. Chairman. Christy Merrill with the Virginia Poverty Law Center, and we do strongly support this legislation. This is a problem that we have seen in the Richmond area and other areas across the state. And I would offer, in response to Senator Stewart's question about the constitutionality, that this only applies to contracts that only last 30 days in any event, and it is a statutory requirement that the landlord give 30 days notice. It simply changes the statutory requirement from 30 days to 60 days in these very, very narrow circumstances. So we'd ask that you pass the bill or report the bill. Thank you.
Thank you, Ms. Mara. Yes, please come forward.
Mr. Chairman, members of the committee, Isabel McLean with Housing Opportunities Made Equal of Virginia, and I just want to say that we support the bill, and I associate myself with the comments of the previous speaker. Thank you.
Thank you. Okay, are there any other questions or motions on this? Okay, there's a motion and a second to report.
Is there anyone here against?
Well, yeah, I should ask that. Is there anyone else? There's a motion now, but is there anyone who'd like to speak against this legislation?
Mr. Chair, if I could just say that I do appreciate the gentleman that brought forth the substitute. I was told that the opposition that was given in the House has now been solved with this substitute.
Thank you. Okay, so we will proceed to vote on HB 2441. Please indicate your preference on the vote board.
Ayes 11, noes 4.
Thank you, Mr. Chairman and members.
Thank you. Okay, is Delegate Cherry here? No? Okay. Delegate Avoli? Is this bill, I'm hoping we can do this quickly because we're supposed to be back in at 3:30, so was there any, let's see, which bill number is yours?
Thank you, Mr. Chair. This is HB 1817. It's very simple and straightforward. It allows a locality in case of a unclaimed descendant to be able to recover the cost of the cremation only if there are assets. It does not affect the family. And it happens quite often, especially in the I-81 corridor, and this is on behalf of the City of Stanton. I'll be glad to answer any questions.
I asked counsel, I think this is a different bill than allowing small assets to be used for funeral expenses.
Yeah.
It's what? It's different. Oh, different bill. Okay, but not conflicting with it. Okay, are there questions for the delegate?
A question.
Senator Rouse.
Does this apply to inmates who may have passed away in prison and bodies go unclaimed? That's the chair. Oh, okay, sorry. Small bill.
Okay.
Okay. Okay. Are there any other questions? Is there any? Okay, there's a motion and a second to report. Is there anyone in the audience who's compelled to weigh in? Okay, I've got a motion to report HB 1748. Please indicate your preference on the voting board. 1817. Oh, I'm sorry, I'm looking at the wrong, 1817. Okay, thank you.
1818.
Ayes 10, noes 5.
Okay. And did you have another bill?
Yes, sir. Mr. Chair, the second bill is 1818, and this is on behalf of Augusta County, which is part of my district. Augusta County is the only municipality in Virginia right now that does not have a fire zone, and a fire zone basically allows a locality to access a tax to support fire and rescue. as counties begin to grow and the demands are there and the demands on trained personnel, our volunteer base is starting to dwindle and it is very, very expensive. So what Augusta is asking here is to have them permitted to have a fire zone just like every other municipality. Like I said, they're the only ones in the Commonwealth of Virginia that do not have this. I'd be glad to answer any questions.
Okay. Any questions for Delegate Avoli?
Mr. Chairman, I'd move to report the bill. I understand Augusta County has a lot of mulch fires, and
Yes,
they
sir.
need some additional resources.
Move to second.
Okay. So there's a motion. Is there a second? Okay.
Second.
A motion and a second to report HB 1818. Please indicate your preference on the vote board.
Ayes 11, noes 4.
Okay. And then Batten. Okay, Delegate Batten.
Thank you, Mr. Chair.
Is yours, let's see if we can't do this really quick. What's your bill number?
Yes, Mr. Chairman. This is House Bill 2223. It's very simple.
Okay, this has to do with the Conflict of Interest Acts, the Statement of Economic Interest for the Innovation Partnership Authority. Is this one that we've already passed?
No, Mr. Chairman. I do
Okay.
not believe there's a companion to this, but it does simply add the Virginia Innovation Partnership Authority members to the purview of the Ethics Council, which means that they simply have to file a statement of economic interest as we do.
And this is a relatively new board that was not added when
That's
it
correct,
was
and
established.
they desire to be added to this.
Okay. Are there any questions? Is there a motion? Okay. There's a motion and a second to report HB 2223. Please indicate your preference on the voting board. Okay.
Ayes 15, no 0.
Thank you, Mr. Chairman, members of the committee.
Okay, can we preserve this sign-up list so that when we
Mr. Chairman?
Yes.
So Delegate Cherry's bill is identical to Senator Donovan's bill, if you want to
It
take
is.
care of that real quick.
It's identical to my Senate Bill 1276 that went through Education and Health with 15-0 passed
Oh,
out of the
yes.
committee. I said I'd speak to it for him.
Okay, so this bill passed the Senate unanimously and provides for autopsies for decedents in the custody of Department of Corrections. Is that correct?
Correct.
Okay.
I do believe there's a FISC. Not that I want to say that, but it's covered in the budget. Yeah.
Move to report and refer?
Yes.
Okay.
yeah.
So there was a this is on the list for the other?
Yes, it is.
Okay, so this needs to go to Finance. So the motion is to report and refer to Finance. And I heard a second, did I?
Second.
Okay. All in favor, please indicate your preference on the voting board, and opposed do the same. Okay, so the Senate is going back into, did we adjourn just till 3:30?
Yes.
Okay, so we're going to have to go back upstairs and come back down here.
We got just a couple more.
What's the next patron? I've got Delegate Ware.
We've got 5 people.
Okay. Yeah.
6 or 7.
Okay. Delegate Ware, why don't you present HB 2494 for us on Powers of Cities and Towns, report to the Housing and Community Development?
You pretty well summed up the key points, and it's very akin to the purpose of Senator Locke had a bill very much along the same lines in the category of great minds think alike. It basically would set up a annual report, clearinghouse being the Department of Housing and Community Development on new land and zoning changes by localities. And the concern, of course, is the additional costs that are conveyed in this and what's happened to the price of housing. We've worked with stakeholders in the local governments, and there is a substitute that incorporates a couple of amendments that they've asked for.
Okay. There's a motion and a second to adopt the substitute for HB 2494. Please indicate your preference. Those in favor will say aye. Aye. Any opposed? Okay. If staff could pass that out, is there anything else we need to know about this little bill?
You've got the key.
Okay. There's a motion and a second to report HB 2494, the amendment in the nature of a substitute. Please indicate your preference on the voting board. I guess we have to go back up.
Ayes 15, no 0.
Okay, let's.
Thank you, Mr. Chairman, members.
Okay, let's keep going and see. I've got next on the list, I've got Delegate Greenhall. Hi. Which bill was yours?
I have House Bill 1953.
Okay, this has a FOIA closed meeting exemption regarding home instruction of children. Do you want to summarize that for us?
Yes, it's very simple. By code, superintendents and school boards are not allowed to make public information concerning families who intend to homeschool, information given by parents. But also by code, they can only have closed meetings for certain purposes. This simply gives them the right to have a closed door meeting with parents to keep their information confidential.
Okay, and this has been a problem in recent months or years, I guess?
Well, we had, I know of a couple of cases last year. Most school boards do these in private, but in Prince George, there was a school board who actually identified the names of the parents and the minor children and their physical home address. So these really do need to be behind closed doors, sir. Thank you.
Okay. Any questions from members of the committee? Okay. Any witnesses in support of this?
Hi, I'm Ann Hoopsick with the Home Educators Association of Virginia, and we support the bill. Thank you.
Thank you. And come forward, sir.
Thank you, Mr. Chairman, members of the committee. I'm Scott Woodruff, Homeschool Legal Defense Association. This bill just gives boards the option of going into closed session to discuss homeschool issues. I support the bill. Thank you.
Okay. Were there any opponents to the legislation? Okay, there's a motion and a second to report.
Substitute motion, Mr. Chair.
Substitute motion, yes.
Move to PBI.
Okay, motion to PBI. Okay, and a second. Please indicate your preference on the voting board on PBIing 1953.
Ayes 8, noes 7.
Okay, that bill fails to report.
Thank you, Mr. Chairman.
Okay, then we've got Delegate Willett. We took his bill, right? He was in the queue. Delegate Munden King. Hi. I see Delegate Murphy in the waiting patiently. Okay, Delegate Munden King. Yeah, I see you're on the list. Delegate Munden King.
Thank you, Mr. Chair. House Bill 2082 is a bill to protect Virginians living in apartments by codifying practices related to background checks and the storage and maintenance of electronic keys. This will require background screenings for all apartment employees who enter apartments and require apartment complexes of more than 200 units to develop written policies for the handling of master keys.
Okay, so basically, if you have more than 200 rental units and you have access to the keys, you go through a background check, and you have to have a policy in that situation?
Correct.
Okay. There's a motion to report and a second. Please indicate your preference on the voting board.
Ayes 12, noes 3.
Okay, thank you.
Thank you, Mr. Chair, members of the committee.
Let's take Delegate Davis. I think we can keep that.
Mr. Chairman, I have House Bill 1810 in front of you. This may look familiar. It passed out of the Senate last year in a bipartisan manner. Went across the street, ran into some problems. So I've got it again this year. What this bill does is basically it ensures that every every local employee that speaks in front of a local or state political body during the public hearing portion of a meeting shall not be able to have retribution taken against them for comments they say. It also makes sure that any state employees that speak in front of a local or state political body during a public comment period cannot have a retribution taken against them for what they say. The only two exemptions are when speaking in front of this body, or in front of the General Assembly and State Corporation Commission. No political speech protections exist today, nor will they exist after this bill were to pass. But their protections exist for everyone else who's employed local or state level in front of all other political bodies, Mr. Chair.
Okay, yes. Senator Stewart.
Thank you, Mr. Chairman. I think Senator Peterson had this same, this is basically an anti-SLAPP bill, right?
I'm thinking SLAPP differently than you are, so I'm thinking my college days.
Than Senator, okay.
That's right.
Any questions or comments?
Follow-up.
Senator McPike.
So to Senator Stewart's question, Senator Peterson's bill, I believe, dealt with any time that an employee was making a claim of fraud, waste, or abuse in front of that public body. This is much different. This is a conscious clause, meaning if, they say balloons are flying over Alaska and we want to shoot them down, I don't know, just throwing something out there.
Sure.
And it conflicts with the employer, it's a conscious clause, they can say anything they want without any recourse in front of that public body, correct?
Correct, yes, sir.
Yeah.
Yes, sir.
Mr. Chairman.
Senator Hashmi.
Question for the delegate. I'm not sure I'm fully understanding between what Senator McPike just said. If a state employee speaks in a public committee meeting here in the General Assembly, are they protected or not protected from, for instance, punishment by the employer?
In the status quo without my bill, there is no protection.
This is local government, your bill. Is there any protection for state government?
Yes, sir. It's local and state. There's two pieces. But I would say that today, before my bill, if it were to pass, there's no protection for a state employee who speaks in front of this body if they were to make some comments that were offensive or demeaning to their department. After my bill passes, if it were to pass, there still is no protections for that. However, if they were to speak in other bodies, political bodies, local and state, those protections would be there for them. And same thing at the local level, sir. I can't solve 100%. I can solve 98%. So I took the 98%.
Secondary.
Was that a substitute?
Substitute motion. Move to gently PBI.
Okay, so there's a motion. The superior motion that will be voted on first would be to PBI. All in favor, please indicate your preference or opposition on the board.
Ayes 9, no 6.
Okay, thank you.
Thank you, Mr. Chair.
Okay, now we've got Delegate Murphy. You're in the express position.
This is a very long bill. You're going to be sorry. Thank you, Mr. Chairman. This is House Bill 2077. It requires that all attorneys who assist veterans with VA-related claims and appeals processes provide a written disclosure informing all their clients of the free services provided by the Department of Veterans Services for members, veterans, and their families. This bill passed the House unanimously. It is supported by the administration and the Virginia Department of Veterans Services.
Okay, there's motion and a second to report HB 2077.
And it's supported by Senator Reeves as well.
Please indicate your preference on the voting board.
That's a tough one, guys. Thank you.
Okay. Delegate Corey,
Ayes 15, no 0.
forward. Okay.
Thank you very much, Mr. Chairman and members of the committee. My bill is even shorter than hers. I won't read you the language. I'm sure you have it
This is 2498,
before you. Yes.
training on Virginia FOIA for local officials
Yes.
of park authority boards.
Yes. Park authority boards are the only body that's not included in the list in the code that have to have their members trained in the FOIA procedures.
Okay, there's a motion to report. Is there a second? Okay, all in favor, or indicate your preference on the voting board.
Oh, goody.
Ayes 15, no 0.
Thank you.
Thank you for your patience.
I can't wait to talk to my park authority. I shouldn't have said that. Oh, I'm sorry.
Thank you.
Erase it.
Thank you.